Does taking the Fifth mean the same thing as the right to remain silent? And if you say it, doesn't everybody assume that makes you sound guilty? Then why would you say it over 100 times during a 3-hour committee meeting? Hello there. I am Michael Allen Lake from Xpanded Universe, and this is an explainer video on the difference between taking the Fifth and having the right to remain silent. Please do like and share our video. We are a young channel, and that small act means a lot to us. Now, to start out, this is not legal advice. This is editorial commentary. I'm a history nerd and a policy wonk, and this is an explainer video from that perspective. At the time of recording, folks in and around Washington, D.C. are all at Twitter about the recent testimony of Dr. Anthony Fauci to the Senate Homeland Security and Government Affairs Committee. Now, as background, on June 23, 2026, Senator Rand Paul, chairman of the committee, subpoenaed Dr. Fauci to testify on the origins of the COVID-19 virus. On July 29th, Dr. Fauci showed up to speak with the committee. To say that Fauci and Paul don't like each other is, let's call it a massive understatement. And if that's news to you and you don't know why, just Google it or ask your preferred AI. Trust me, you don't want to waste time discussing it right here and right now. Over the course of 3 hours, each and every time Fauci was asked a question, he responded with some variation of, on the advice of counsel, I respectfully decline to answer based upon my rights under the Fifth Amendment of the Constitution. And journalists, late-night comedians, internet pundits, well, I mean, those who are focused on DC politics, that is, they have kept talking about this. However, I noticed that a number of them kept swapping out take the Fifth for exercising his right to remain silent. And that felt weird to me, because in my mind, those two shouldn't be the same thing. Or should they? Now, in everyday language, we do use those two phrases if they're interchangeable, but ultimately they come from different centuries and are designed to solve very different legal problems. Taking the Fifth refers literally to the Fifth Amendment of the U.S. Constitution, part of the Bill of Rights that dates back to 1789. Yes, I know. Don't at me. It wasn't ratified until 1791, but the pen was put to paper several years before that. And the existence of the Fifth Amendment, or at least of the clause against self-incrimination, was a direct response to the way things were run in 16th and 17th century England and their inquisitorial form of justice. Remember inquisitorial form of justice? We're going to come back to that in a little bit. However, in those courts at the time, the accused were forced to swear an oath ex officio, a religious-based oath where the accused would affirm to answer all questions truthfully and before they were even told what charges were being brought against them. You were forced to answer questions without knowing why or what the evidence looked like. A case in 1637 involving the Puritan known as Freeborn John Lilburne brought an end to this process as he refused to testify against himself. This was a very public trial, and it helped demonstrate that forcing someone to confess under oath was tyranny, not justice. The fallout led Parliament to abolish this form of Star Chamber justice and enshrined the concepts of a right to remain silent in English common law. And that fact was very much on the Founding Fathers' minds when they were forming their new country. Now, just as a quick clarification, I use the term right to remain silent just now, but that's because it became a household term. Or rather, it's become a household term. It was not known as that in English law, and even the U.S. Constitution doesn't use that phrase. The Constitution says that no one can be compelled, quote, to be a witness against himself, end quote. In essence, it's a right against self-incrimination. But now the phrase right to remain silent didn't come along until 1966, when it was introduced into the canon of American law by the Supreme Court itself. And that featured in the landmark case of Miranda versus Arizona from, as I said, 1966. You may not have heard of the case, but if you've watched any American police procedurals or cop dramas in, say, the past 50, 60 years, you've heard of people getting Mirandized or read their rights. Right to remain silent. Right to an attorney. If you don't have an attorney, etc., 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 etc. Chief Justice Earl Warren wrote that, quote, prior to any questioning, the person must be warned that he has a right to remain silent, that any statement he does make may be used as evidence against him, end quote. So in essence, it evokes the same concepts of the Fifth Amendment, but in a very different language and for a very different purpose. Think about it as similar DNA, but in different bodies. The Fifth Amendment is all about what happens in a courtroom or a proceeding. The Miranda rights are about investigation and law enforcement. So why does that language resonate with all of us now? Hollywood. Television creators realized that just seeing the cops handcuff the suspect was one thing, but having them read the suspect their rights while taking them away, that added a layer of dramatic tension to the scene. And after decades of Dragnet, Adam 12, The Closer, and Law & Order, the very phrase, right to remain silent, is ingrained in our psyche. Now, to be fair, if you're watching this and you're under the age of 65, you've probably never heard of Dragnet or Adam 12. But the next time you're hanging out with your grandparents, drop those show names into conversation, and I bet they'll be delighted to discuss them and what their favorite episodes were. I mean, I did say as a history nerd, right? This kind of just proves that. There's something else that Taking the Fifth and the right to remain silent have in common, and that's that they are both emblematic of our adversarial justice system, one where two parties compete to get to the truth of the matter. Since this whole video is about the nuance between phrases, let me do that with adversarial for a moment. We hear that word in modern context, and we think enemy. That's not the case, at least not in this context. An adversarial justice system is what we have in the U.S. right now. It's a practical and legal application of dialectic philosophy, a system where two opposing parties build and present competing cases. A neutral party, a judge or a jury, they serve as referee and arbiter. Basically, lawyers drive the process, the gathering evidence, the questioning witnesses, building arguments, and then the judges rule on procedure and points of law instead of directing the actual investigation. The state does not both investigate and judge/decide. Those roles are actually split between the two groups. This type of jurisprudence is in use in countries such as the US, the United Kingdom, Nigeria, and India. Usually, but not exclusively, it's rooted in the tradition of English common law, which is why you find it so common, if you will, among the Commonwealth countries. In addition to being a history nerd, I love a bad pun. Now, the alternative is the Inquisitorial system, which is often predicated on a civil law tradition. In these systems, the judge is not a neutral arbiter of competing narratives that are presented by the lawyers, but rather the judge plays a much more active role. They may direct the investigation, question witnesses, and even assist with evidence gathering. Prosecutors and defense attorneys do have a role to play in the system, but the judge is the one who drives the fact-finding process. Now, much of this tradition traces back to a mixture of both Roman law and the Napoleonic Code. Thus, you will find this type of jurisprudence in use in countries such as Germany, Argentina, and France. Because, if the Napoleonic Code wasn't in vogue in France, that would be kind of funny in its way. However, interestingly, some countries have a mix of these jurisprudential processes. Switzerland, for instance, follows an inquisitorial process for criminal law cases, but an adversarial process for civil law cases. Now, one final fact in closing. Taking the Fifth is clearly designed in the U.S. for criminal case law, for suits involving the government. So in the U.S., can you plead the Fifth in a civil trial? And the simple answer is, sure. However, it makes for a weaker defense. In a criminal trial, if you invoke your Fifth Amendment right against self-incrimination, the jury will be instructed they cannot hold your silence against you. They cannot read anything into your refusal to say anything. Civil law does not allow for that. There are lawsuits, in civil law, these are lawsuits between and among private parties. So if you take the Fifth and say nothing, your opposing lawyer is allowed to argue that you're hiding something, that your silence helps to prove your culpability. So in that instance, taking the Fifth and right to remain silent are definitely not the same thing in that instance, and not in any practical sense. And again, this is from my perspective as a history nerd and a policy wonk. This is not legal advice. But that brings us back to Fauci and the 29 July Senate hearing. A congressional hearing can be considered an odd hybrid of public hearings, criminal proceedings, and also civil proceedings. You can plead the Fifth. There's nothing stopping you. But nor is there a judge or magistrate there instructing people not to hold that against you. Taking the Fifth is not an admission of guilt. But in a public, open hearing like that, various people, members of Congress, the press, the public, they may read into that as an admission of guilt, especially when no one is there to direct them otherwise. And as of this recording, there is still some debate on whether that strategy was the right one for Fauci and his legal team. Don't get me wrong, it's absolutely his right to invoke the protection against self-incrimination enshrined in the Fifth Amendment. That has been a hard-fought and hard-won right for the American people. But it's not exactly the same thing as the right to remain silent. As I referenced earlier, they have similar DNA, so if you hear somebody use them interchangeably, it's understandable, and you can pretty much guess what they mean. But it's also an example of why, as we like to say on this channel, you should trust, but verify. If you would like to learn more about the Fifth Amendment and how it contains much more than just the protection against self-incrimination, we have included several links in the description below that help you, the links to places that help to sort of explain what the Fifth Amendment is. Each one is a resource aimed at explaining the Fifth Amendment in plain language for the non-lawyer and non-legal scholar. And in closing, I also just want to say, remember, you matter. Whether you're worried about self-incrimination or just feeling the pressures of today's world, taking care of your mental health isn't selfish. It's necessary. Be kind to yourself.